I start by saying, of course, that the previous speaker is absolutely right, that workers shouldn't rely on the law or on courts or on lawyers to protect their health and safety at work. But having said that, and I'm sure I know all our previous speakers would agree, that's no reason not to have the best possible laws that we can have to protect health and safety at work, and the best possible enforcement of those laws. Nobody doubts that the current health and safety legislation is not good enough. For example, under the heading of our subject this evening, the right to stop the job, we don't have the right to stop the job, but shop stewards in Australia do. It's written into the legislation there, and we ought to have the same thing. Nevertheless, the fact is that we do have a series of pieces of legislation which are very relevant to the issue of COVID-19 and which I think are under threat. And that's something I want to raise with colleagues this evening. Let me just mention what the rights are. We have a right to a safe place of work, to safe workstations. We have a right to employers making a risk assessment. We have a right against the substances hazardous to health at the workplace. We have a right for reportable diseases and injuries to be reported to the authorities. We have a right to personal protective equipment. And in particular, the one thing you want me to mention is we have a right not to have a detriment or dismissal imposed on a worker who refuses to work because they have a reasonable belief of a serious and imminent danger. And those are the critical words of Section 44, which protects against, Section 44 of the Employment Rights Act, which protects against detriment for health and safety reasons, and Section 100, which protects against dismissal. So let me just mention those words again, and we can discuss them in questions later. A reasonable belief that the worker or others is in serious and imminent danger. And here, of course, we're talking about danger of infection. Well, nobody can doubt that the risk of COVID-19 is a serious risk. The question will always be whether it was imminent or not. But that question is a question for the worker and not for the employer. It's the worker's reasonable belief as to whether he or she faces a serious and imminent danger or not. Now, of course, that's always got to be assessed on the facts of the particular case, the circumstances in which the work was done, the circumstances of the workplace, what information there was available to the worker, and so forth and so on. And perhaps we can discuss some of those later. But those regulations that I've just mentioned are very, very important, as Steve has outlined. And anybody who's a health and safety representative, any one of those 100,000 people in this country are familiar with all those regulations. They may not know the wording off by heart. They may have to look it up on the web to get the precise words, but they know those regulations. They know that they exist. Now, what I want to draw the attention of comrades to is this, that last Monday, on the 11th of May, the government published 8 sets of guidance to workers and employers for working during COVID-19. Each one runs to about 28 pages, and they are addressed to various sections of industry. There's one, Dave, specifically for the construction industry. Now, what's remarkable about them from a lawyer's point of view is that they do not mention anywhere any of those regulations that I've mentioned. There is not one word of the existence of those regulations. All it says is that employers have a responsibility to keep the workplace safe. And as Steve has mentioned, they are in some places deliberately, I think, deliberately misleading. Let me read to you what it says about PPE. And they all say the same thing. This is a cut and paste job for all 240 odd pages. This is what it says. It says, when managing the risk of COVID-19, additional PPE beyond what you usually wear is not beneficial. This is because COVID-19 is a different type of risk to the risks you normally face in a workplace and needs to be managed through social distancing, hygiene, and fixed teams or partnering, not through the use of PPE. And then it says, workplaces should not encourage the precautionary use of extra PPE to protect against COVID-19 outside clinical settings or when responding to a suspected or confirmed case of COVID-19. So no additional PPE is required, and workplaces shouldn't encourage its use except in clinical settings. I don't know if clinical settings includes care homes, but I would have thought probably not. And I find this amazing because, as Mick Cash would have said were he here, if you travel on Eurostar, every passenger is required to wear a face mask, and they are handed out free of charge. But the problem for me is that this appears to conflict with the PPE regulations, because Regulation 4, if I can bring it up, Regulation 4 of the PPE regulations, and I can't, but I can remember it more or less off by heart. Regulation 4 of the PPE regulations says that an employer has a duty to provide PPE to every worker who faces a risk which in effect cannot be eliminated by any other means. Steve is right. Of course, you try and eliminate the risk at source, but if you can't do that, then you may have to resort to PPE. Now, there are lots and lots of workplaces and lots of work situations where the risk will not be eliminated by social distancing or hand washing or cleaning of surfaces used by workers or desks or keyboards. The risk will still remain. The workers that Dave mentioned, the construction workers who are told, well, you can work within 2 meters of each other, but not for more than 15 minutes, are a case in point. Or that poor ticket inspector who died the other day, Belly Mujinga, who was spat at by a customer and subsequently caught the disease and died. Now, whether that's foreseeable or not is a different matter, but it shows that lots of people have in their jobs to mingle with other people or work in confined spaces with other people where the air is not frequently changed and so on, and where other measures cannot eliminate the risk. Well, in those circumstances, Regulation 4 of the regulations is absolutely clear. PPE has to be provided. So this guidance is, I think, really outrageous, and it's something that Shelley and the TUC and the unions really ought to take up. But the problem is exacerbated because later last week, the Health and Safety Executive itself produced a publication, and this is called Working Safely During the Coronavirus Outbreak, a short guide. This too makes no mention of any of the regulations that we've talked about this evening, not a single mention anywhere. It does say that employers should carry out a risk assessment, and as an employer, you must protect people from harm. But it doesn't say that there are statutory duties and that breach of those statutory duties is a criminal offence. And it doesn't spell out what those duties are. No mention of PPE, for example. All it says is that employers, quote, should think about various precautionary measures. Now, this troubles me. If the regulator of health and safety is not prepared to put out guidance to the workers and employers of this country, stating what the law requires of them, we are in a very serious position. And I couldn't help noticing that on Friday, the Brexit negotiations broke down for, amongst other things, the fact that the UK government is not prepared to accept the level playing field that the EU is demanding in respect of environmental and workplace law. And I wonder whether the reason that these regulations are not mentioned in any of these publications is because the government is clear that what it's going to do is repeal the regulations that derive from EU directives, and all the regulations we've mentioned this evening do derive from EU directives, so that we can have the benefit of lower workplace health and safety standards than our colleagues do in France and elsewhere in the European Union. That would be absolutely outrageous. But of course, as we know, next week the Parliament is going to be debating the trade bill, which of course has got as part of its objective cheap trade with the United States with lower workplace standards than we have here. And I wonder whether the ultimate intention is not to make our laws equivalent to theirs for the purposes of obtaining trade. I find this very, very worrying indeed. Let's hope I'm just being too cynical. Thanks for listening.